Okay. We're going to call this meeting to order. It's 3:05 p.m. on Monday, July 14th. Victor Young is our clerk and administrator. Mr. Young, could you please call the roll?
On the call of roll, Member David.
Present.
David present. Member Oka.
Present.
Oka present. Member Highland.
Present.
Highland present. Chair Pilpil.
Present.
Pilpil present. We have a quorum.
Thank you. In terms of agenda changes, let's see who's here. I see Mr. Zitrin from the City Attorney's Office. I see the brothers Clark. Thank you. Welcome. Is Mr. Gonzalo Ferrer here? I don't know Mr. Ferrer. I don't see him. So what I would suggest we do is take item 3 first, if we might, and then we'll see if Mr. Ferrer is here. We'll see how to proceed on item 2. Does that work for everybody? Okay. Without objection, we'll take item 3 next.
Hello, gentlemen.
One moment,
One
please.
moment.
Sure.
Item number 3, file number 14019, hearing on the status of the order of determination. William Clark against Dennis Herrera, Jack Song, and Gabriel Zintrin, City Attorney's Office, for violating Sunshine Ordinance Section 67.29.7 for failure to maintain appropriate records in a businesslike manner.
Okay. So we're on item 3, starting on page 119 of the packet. Why don't we hear from Mr. Clark first as to the status of the matter, and then we'll hear from Mr. Zitrin and perhaps have some discussion about the appropriate record keeping for billing hours of the city attorney. Go ahead, Mr. Clark.
Thank you. First, I just want to point out a couple of things that I've discovered since the last hearing. At the last hearing, the task force was told that the city attorney sent an email to me that they would have received some sort of notice, and that if my email box was full, that they would have gotten that I would have been notified that of. This is a copy of my Earthlink company, and there's a message there that says that if my mailbox is full, that any emails sent to me would be sent back to the sender marked, what's it say, marked?
Undeliverable.
Undeliverable. So they would, had they sent something to me and my mailbox was full, they would have received an undeliverable message. They claim they didn't. I also want to point out a couple of things that confused me, because at a different meeting, Howard Lazar sent, in his opinion, he sent a statement saying that on April 8th, 2013, he received information from the city attorney, and then on here, it says April 16, right here.
What document is this?
This is one from a different SOTF complaint that was made, and this was Howard Lazar's response. And in it, he states that he contacted, on April 16th, he contacted the city attorney's office again and consulted with them and got some answers. And I just want to point out to you on this, and that he also had a conference on April 8th, and I want to point out to you on the billing sheet that's in controversy here, which is right here, there is between April 8th and April 22nd, there's no notice at all of any conference that was held between the city attorney's office and Howard's office. So I'm questioning why those conferences weren't completed. And then I want to also show you that in the past, from 2010, the city attorney always communicated to the Arts Commission by email and through Adine Vera and their office on the public documents. I have numerous emails here. I have numerous emails here. If you notice, it's regarding Sunshine cases, and these are, I just want to show you real briefly because I don't have much time, but I have numerous emails between the Arts Commission and Howard and the city attorney discussing by email all these different cases that took place. I can provide you with copies of this. So what I'm saying is that as of 2010, the city attorney was communicating by email constantly with the Arts Commission on sunshine requests. Now, all of a sudden, we are being told we have no records, emails, or anything like that. And I would like to know when they stopped communicating by email regarding these disclosures and everything, because I have 10 other pages of emails here that were communications specifically on sunshine requests between the Arts Commission and the City Attorney's Office. And so where I'm coming from is, like I said, all of a sudden we're being told this is all over phone, we never emailed, there's no records, there's no nothing. So I just want to make your committee aware that I found this, and depending on what you do, if this goes back to the full task force, I do intend to bring this up, because right now all we're requesting is that on the billing sheets that there be some explanation when it's a sunshine case of what the advice was asked for regarding a sunshine complaint, and also what the advice was that was given to the department, so that we can verify what's being told back and forth. And like I said, as of right now, this year they're claiming they have no paper records of anything, and I can produce dozens of emails from previous years that dealt specifically with sunshine requests. So I don't know what the next step is from your point, but so far we've gotten nothing.
All right, well, we will figure that out. If you could put on the screen the billing record, because we don't actually have that in our packet today, and that would actually be helpful. I just want to remind everyone that the issue before us today is actually the billing practices and documentation required as support for billing statements. That's indicated in the order of determination, page 1 of the order, page 120 of the packet. So that's what I want to focus on today.
I'll just leave that the
That's
whole
great.
packet.
I appreciate that.
Yeah.
We'll have questions for you in a moment.
Okay.
Thank you. Why don't we turn to Mr. Zittrain?
Support?
It's actually not.
Your call.
Yeah, we're just going to hear from the separate parties, and then we're going to open it up to public comment and discussion. So go ahead, Mr. Zittrain.
Afternoon, task force members.
Thank you.
So sticking with the order of determination that came out of the full committee, I wanted to take you through, you're looking at, this is the spitting out of the records and how they're brought there. They are, and I was actually a couple of times sitting next to Adine Vara as she was entering the records and looking at the specific fields. Now, these specific fields have actually gotten more specific. The full task force recommended to the Arts Commission that they request a more specific than usual billing practice from their counsel, the City Attorney's Office, and we got together with the client. We complied. We created a couple of new designations, which originated with task force action, and the client, the Arts Commission, has done very well, and now, it's gotten...
Remind us what those codes were?
Sure.
PNS, PRS, something like that?
Yeah, PRS, Public Records Search, Review, and/or Response. RAM, which is Research or Advice on Meeting Issues, and RAR, which is Research or Advice on Records Issues. Got it. Now, I understand that Mr. Clark just said we're looking for the content of the advice sought and the content of the advice provided. We cannot provide that, as that is covered by the attorney-client privilege, which the attorney being us and the client being the Arts Commission. We can get as specific as we have gotten, and we can, if there's a way to get more specific, I don't know what it is, but we have, what we don't have, as I will say, is the method of, the medium of contact. And whether it was done by phone or email is not indicated on these billing records in this particular fashion. The reason being that in the field that the attorneys have available to them when they enter in, TEL is a code that would have to be, for telephone call, would have to be in place of PRS, such as Public Records Search, RAR, which is Research or Advice on Records Issues. So whether that time that you see as an hour designation was spent doing email or spent on the phone is not going to be indicated. Although there's no real reason it couldn't be included in comments, but it doesn't sound like that would address Mr. Clark's concerns anyway, as those comments would under no circumstances include the content of the advice sought by the client or the content of the advice given to the client. So beyond that, I'd be happy to address any other questions you have on the order of determination. But I want to stress that we don't intend to provide, we cannot legally provide the content of the advice sought by the client. The client can waive the attorney-client privilege, but the city attorney cannot. Thank you.
Great, thanks. And we'll have follow-up questions for Mr. Zittrain in a moment. Any initial thoughts, questions from members of the committee? No? Okay. Why don't we do this? Let me bring up Mr. Zittrain again, and then I'll go back to the clerks. I recall when we discussed this some time back, and I think you and I have talked about this since. Can you pull this down just a little bit? Great. So my understanding is that there are at least 6 different fields that the attorneys use for billing. The code, I guess this 000496, is the Arts Commission Street Artist Program. That's the client or the matter number. The staff who we see here, Adine Vera on this page, but we've also seen other reports that indicate Ms. Jessen, Ms. Gessner, perhaps others. Category, in this case, Public Records Brown Act. I think you suggested that that's now been superseded by those 3-letter codes?
It has not been superseded so much as there are now more options.
There are more options, okay. But those are selected from, I guess, a pull-down list? So those are what's the word?
Pre-programmed in, they are part of
yes,
the
that's
program.
a technical term, pre-programmed, sure. But my understanding is that there's an additional field that we're not seeing here that's description, that is kind of an open field that allows attorneys to provide more detail and description about the matter discussed. Is that correct? Is my understanding
I think
correct?
there is a freestanding notes field. And I don't know off the top of my head whether it's labeled notes or whether it's labeled description.
But it's something.
It is something. I think it is something, and I think it is not from pull-down menu, but it is free-flowing. They can type whatever it is that they want.
Okay, and if there is that field, then I assume that this time billing report can also be structured to provide that detail for that
I
particular.
would assume so,
Okay.
but in the event that somebody were to request it in that form, we would have to go through and make sure that there was no information that was confidential
Correct.
before we issued it.
Okay, but there would be a way to disclose it. And
I think so.
And that's what troubled me the last time we went through this, is that there was no more detail provided besides this,
My understanding is that unless, it's not always going to be utilized. In fact, it may not even usually be utilized, if only because of the specificity of the recently adopted fields. We've already got, you're discussing the street artist program with the Arts Commission for such and such a time.
Right.
And in addition, it's going to be, for example, research and advice on records issues.
Okay.
I mean-
So let's just go with this for a second.
Mm-hmm.
So if you can step aside for a moment, if I could bring up Mr. Clark again.
Through the chair. I'm just curious, is there anything to the right of those numbers? It looks like...
I think there's just a total amount over there, because it's separated between hours, or attorney and assistant hours, and
I see.
dollars, and then total.
All right. Thank you.
But thanks. So, Mr. Clark, did you happen to bring the Arts Commission log with you as well?
I don't have the Arts
Okay.
Commission log
But
with
we've
me.
seen it before, so that's cool.
Right, but
Okay.
the only problem with that is that's the Arts Commission's log that they keep those records of. These are what we're
Understood.
discussing is this. Okay, go ahead.
But what I'm trying to figure out is if we could get the city attorney to use that more descriptive field, what sort of information would we desire to have recorded there?
Well, I don't think, after hearing what he said, I don't think those extra fields explain anything. They're another way of saying they're dealing with aspects of the Sunshine Ordinance and certain requests. I don't see any, the information I'm asking for is not included in those new descriptive fields.
No, I understand. So that's why I'm trying to get more descriptive. So let's say, for example, this first item, let's just take that for a moment. July 24th, 2012, Adine Vera regarding public records, or public requests, whatever, / Brown Act, an hour and a quarter. So presumably that was also logged on the Arts Commission's log, and that was probably, and Mr. Zittrain, I don't know if you've seen the Arts Commission's log. We can certainly get that to you. Mr. Lazard helped create that. Ms. Patterson, I think, at the Arts Commission works with that as well. That would indicate what particular matter, whether it was related to a request that you had made, or a Paula Detesh question about a whatever.
Right. That would
So-
make me have to search through both records.
Right, but I think what we're trying to get at here is some greater detail here that ties it to something specific.
I
That says
understand what you're
Detesh question, or, Market Street art certificate inquiry, something that you can
Refer back.
refer back to and that makes some sense. This just says, heck, we did something, Adine talked to somebody,
Right.
did
However,
something.
I just want to point out that if
Yeah.
you remember in that log, the Art Commission refused to include at the end of it what the advice was that was given to them.
Correct, and I don't think we're going to get the advice requested or the advice received. I think that's beyond the.
I understand his point, but he's claiming it's attorney-client privilege, and I'm claiming it's not attorney-client privilege, that all the information and advice the city attorney gives regarding any public request to a department, that information is not privileged, attorney-client privilege. He can stand up here all he wants and claim it, and you can accept it. But you know as well as I do that the Sunshine Ordinance says any advice the city attorney gives is public. And since the Arts Commission on their log has refused to include what the advice given was, and now they're not willing to give the advice on attorney-client privilege, I think that I'm being denied that information
Understood.
willfully.
Understood. I'm not sure that we're going to make you happier on that score, so that's why I'm trying to, deal with something that.
Well, he's not making me happy today because he's refusing to give that information. You're not going to get the information out of him today. So
We're not there yet, so one thing at a time. I think Member David had a comment?
So, well, I just want to say that I think that Mr. Clark summed up, I think, the issue before us perfectly. Like, that is the question that we're dealing with, and then that's what I find about this case so interesting, and I think so relevant to many of our cases of, is the city attorney's, the information the city attorney shares regarding sunshine and public records requests, is that covered by what's it called, attorney-client privilege?
All right.
Right?
So why don't we address that for a moment, and then we'll come back to the question about record keeping and billing. So, Mr. Zittrain, let's have it out. Let me try to frame this. In general, not related to sunshine, but generally speaking, advice and discussions between an attorney, in this case a deputy city attorney, and a city department or a city officer is or is not subject to disclosure?
Regarding advice regarding sunshine matters.
Generally.
Or
Let's start
generally,
with generally.
Generally, no, it is not subject to disclosure.
And it's
Subject to the attorney-client privilege.
which means that the client, the city department that receives the advice, can waive that privilege
Yes, they
and
can.
disclose it. They may have to check with others before they do that, but the privilege is held by the client.
Yes.
So the attorney doesn't have any discretion whether or not to release it. It's entirely up to the client.
No, or I think there may be a formality, a system of formality by which the attorney releases it at the client's request, but generally speaking, it amounts to the same thing.
But it's not the attorney's call, it's the client.
No, it is the client's call.
As relates to advice related to the Sunshine Ordinance, the Public Records Act, the Brown Act, how does that work?
Mr. Clark is correct, first of all, in what he said. The Sunshine Ordinance purports to eliminate the attorney-client privilege when it comes to advice that is given between the city attorney and city departments. Our position is that it doesn't do that, that you can't legislate the attorney-client privilege out of existence. And yes, it's tempting to try to litigate that here, but luckily for everyone involved, there is no need to do so, as there's currently a case pending in the Court of Appeal on this very subject. But basically it's derived from the relationship between attorney and client being established under the city charter, and that to the extent there is a conflict between an ordinance passed by the Board of Supervisors and the city charter, the ordinance passed by the Board of Supervisors does say, as Mr. Clark said, that advice regarding the Sunshine Ordinance is not itself, or is not privileged. the city charter, by establishing the attorney-client relationship between the city attorney and city departments, conflicts with that, and the charter wins in a conflict between the charter and an ordinance passed by the board.
And that's
So
the
I just want to correct one thing. It's an ordinance that was passed by the voters, right?
By the voters,
I just want to,
indeed.
yeah.
That's right. Originally passed by the board, but then amended substantially by the voters.
Right.
And that's the argument that you've made before the Court of Appeal.
Yes.
That case is pending. We're all waiting. We assume sometime this month, perhaps in the next 2 weeks.
We can all
we'll get an
hope.
answer on that. Okay. So in the meantime, that is the position that your office is taking,
Yes.
is that that advice is not going to be disclosed, notwithstanding the plain language of the ordinance.
That's correct, in light of the language of the charter.
Okay. Does everyone want to sit with that for a second? Okay, you'll get a chance.
Yeah, you'll get a
I just want everyone to just get what was said, because that's interesting. Okay, so therefore, you're deeming at this point, until the court rules otherwise, that all advice from an attorney to the client is up to the client to disclose or not disclose, and if the client chooses not to disclose, then that advice is not provided to the public.
Right, and that's hardly a new thing. That's as old as the legal profession.
One moment. Member Oka?
Yes, I believe that until this is resolved in the courts, it is up to us, the task force, to determine what is and what is not according to the ordinance privilege or not. And it's not up to the city attorney to decide that. So I would like to be argued out of that if you want to try.
Okay. I have different views on this topic. I'm not sure that we need to get too heavily into this question right now. I think that the issue before us really is the billing records and how they're maintained. I think this is a fun and interesting discussion, and we may get, some better direction on this in a couple of weeks. But I don't want us to just get bogged down on this issue, because I think we have to deal with the billing question. Member Highland? But I appreciate it.
It sounds like a lot of cases rest on this, but this one in particular, the complainant just stood up and told us that's exactly what he's after. Perhaps it might be worth asking the complainant if he would like to continue this, to call the chair, or for 2 months to let this be resolved, because that'll put him in a much better position to get the information he wants. We can do what we can do on the other smaller pieces, but if we close this, then he'll have to start all over again.
Understood.
To start this process. So that might be an option that Mr. Clark might want to consider in light of this case that's going on.
That's certainly true, and when we decide how to dispose of the item, that's absolutely an option. So you're going to have a chance, I promise. I just want to get through this question on billing, and then we'll deal with the question of advice and how to further proceed. So if we were to request your office to include a greater description in that field, whatever it is, and you're going to find out and let us know what exactly
field
that
is.
field is, and if a report can include disclosure of that field, can you give us an understanding of what type of detail you think your office would be willing to include in that field to go as far as you can without, as you indicate, disclosing the request for advice or the advice itself?
I don't know what that would look like right now. When you look at the specificity that is already there in the other fields, as far as this is, the Arts Commission is the department, we have the specific street artist program,
Right.
The amount of time the communication took, or the amount of time that the attorney spent on the communication, and the fact that it was in these new fields, which again were adopted at the suggestion of the task force and then
Right.
the Arts Commission.
So-
Advice,
Okay,
what is
so-
more specific than that does not include these?
So, Mr. Zittrain, you're a fair guy.
I am.
We're all sort of fair people in this
Yes.
room, let's say. Look at the first item on this chart, if you would. 496, we presume, is Arts Commission Street Artist Program. Doesn't that tell you that on July 24th, 2012, Ms. Vera spent an hour and a quarter dealing with some street artist program, public request / Brown Act issue. Is that what that tells you?
Yes.
Does that really, if you were trying to figure out what this was about, does this really tell you anything about what it was about? Does this give you sufficient information to conclude what topic within, the vast world of public request / Brown Act in the Arts Commission street artist program this could be dealing with? Does this really help you? If you were a member of the public looking at this, you tell us.
I think it would depend a lot on what the member of the public was looking for. And in the case of how these records were produced, what the member of the public was looking for is the content of the advice sought and the advice provided.
And to the extent that you can't, or you're saying you're not willing to provide that, is there something in between that you could provide? So, for example, Paula Detesh request of, July 20th, 2012. That might be a description that you could include that was the subject matter that was discussed. I don't know. I'm just suggesting that because that's, entirely possible here. And that would give the reader of this some understanding of how that hour and a quarter was spent without discussing the request for advice or the advice itself, which we'll talk about in a moment.
A perfectly legitimate point, but I would want to direct that question in this case to Mr. Clark because, and ask him precisely what he's, and you just did a few moments ago address that, and there really was no answer as far as what is more specific than this that does not include the content of the advice. Mr. Clark indicated that he's not really interested in what would be in that field.
But we may be interested in getting as much disclosure as we can without going farther than you're willing to go at the present time.
In the case of, I can allow that there is, the name of the person whose inquiry, for example, if this was regarding one of Mr. Clark's requests. That
and maybe the date of the request, if there was something specific to tie it to?
The date of Mr. Clark's request and the fact that it was Mr. Clark's request.
Or Ms. Detesh, or if it was a topic, like our street artist program certificates subject to disclosure. I don't know, I'm just making stuff up. But you could have a topic that was the topic of inquiry without getting too far down the road of the advice sought and provided. And I think we're looking at a minimum for some additional field that gets us closer to that. And I'm hoping that you'll say, yes, you can go back to your folks and strongly urge them to put in this additional field with some additional content.
The only reason I'm hesitant is because some additional content is going to vary from one case to the next.
True.
Of how much specificity is really possible.
And I think we're looking for as much as is reasonable under the circumstances. I'm not looking for someone to write a book or a paragraph on this, but a few words or a sentence or something that gives the reader some understanding of what was discussed. At the end of the day, at the end of the year, actually, I seem to recall there were like 47 instances and, 71 out, some large amount of number of requests and time and money spent on this. So it wasn't just an incidental once a year, hey, I have a 5-minute question, can you just figure out? There's actually a lot of effort put into this, and I think that we've heard repeatedly from the street artist program folks that they are concerned about the amount of money spent on advice related to compliance, and they would like some understanding of what is being discussed, which frankly is not unreasonable. So that's why I'm hoping you'll say we could do a slightly better job on this.
All right.
And maybe if we do continue this, you could ask other teams in the office how they track billing related to public records, sunshine compliance.
So when you say other teams, you mean other lawyers who serve as counsel to city departments?
Correct,
Okay.
Because Ms. Vera is certainly not the only one who provides advice to departments about public records. She's the person who does most of it for the Arts Commission, but certainly MTA, PUC, lots of folks give advice on this. How do they track their billing? Is there some way that we could get to a better standard of how that's tracked? Again, without disclosing what you're not willing to disclose right now. So why don't you think about that for a moment? Let's give Mr. Clark an opportunity to respond. Thanks.
Thank you. First, I just want to make you aware that when we had the other task force hearing about the Art Commission logs, the Art Commission stated that they refused to include in that log what the specific request was from the city attorney on the advice from the city attorney's office that they had an attorney-client privilege to refuse to release that information. Although what you're saying here is understandable, and I agree with what you're trying to do, what I'm trying to say is even if you get a few things in there, there's got to be some way where we can find out specifically what the substance of what the advice that was given to the city, to the Arts Commission from the city attorney. We're not going to get it from the Arts Commission because they're refusing on attorney-client privilege. This gentleman is refusing on attorney-client privilege. Although I tend not to want to continue this for a month, I'd rather you send it back to the full task force next month with a willful refusal to provide the information. I shouldn't have to wait for a court case to be decided for me to be told, okay, while the law is still in effect, that I'm entitled to that information. I feel that you should send this back to the full task force next month with a willful refusal to provide me with this information. And then if the matter's been solved in court by that time, then that can be brought up at that time at the full task force. But I should not be forced to put in, my complaint be put in limbo, which you gentlemen know I've been working on for years to get this information from the city attorney's office. And I feel like both of them are saying attorney-client privilege.
So I have a question for you, Mr. Clark. So I'm just curious, what would you say? So let's say that we do what you're requesting for us to do, right? And that therefore, and the city attorney turns over all the information that he's now saying is attorney-client privilege, and then. I'm saying, let's say he doesn't refuse. Let's say that he actually, everything's turned over, right? And you're like, okay, I got
Well, right now he's saying there's nothing.
I understand.
Okay.
I'm giving you a theoretical situation, right?
Okay.
Because this is what I'm grappling with in my head. You're asking us to do a willful determination, right? That they're willfully not complying.
Well, he is willfully.
I understand
not complying,
that.
right.
But here's my question, though. Once that information is made public, right, it's public. And what if the court case comes back and says that his argument is actually on point, that it's not that the charter trumps the Sunshine Task Force. So my question
Well,
is,
the reason I get you, like you said before. First of all, this is a ballot measure that was voted on by the voters. He's claiming that the charter the charter is Trump. Excuse me. That ballot measure is a charter amendment. It's part of the charter.
It's not.
It's a charter amendment.
It's not. The ordinance is still an initiative ordinance.
Yes, every initiative of an ordinance is a charter amendment.
No, it's not.
Okay, well, we're going to agree to disagree because I wrote the street artists ordinance, and that was a charter amendment, and that was just a regular ordinance. And what I'm saying to you is that this ordinance, your ordinance, is part of the charter. It was voted on the people, which is a higher than the Board of Supervisors. The authority of the people who wrote this ordinance said that this advice is public information. And for 2 years, 3 years, I've been trying to get this. And they're both telling you now that put this off until we get a court ruling. I have no idea. I don't know if I'll be alive by that time. And I think it's unfair for you to sit here and say, well, let's wait until this court case. If it turns out that the court rules against us, he's not he's not, not like your theoretical thing, he is not releasing any information at this time. He's not going to release any information in the next 2 weeks to a month. So therefore, there's no chance that they're going to release any information which later will be determined that it shouldn't have been released. I feel that the full task force should be made aware that at this time they're refusing to provide that information.
Okay. Thank you.
I'm sorry.
So, no, that's fine. So let's just go back to the order of determination for a second. The complaint initially alleged a violation of 67.21 and Government Code Section 6253. The order and determination of the task force was that there was a violation of 67.29-7 for failure to maintain appropriate records in a businesslike manner. There was not found a violation of 67.21 that documents or records weren't provided. It was simply, or not simply, but it was found by the task force that the office was not maintaining records in a businesslike manner and asked that they appear here before this committee to discuss billing practices and documentation required as support for billing statements. So it was really...
I would like to interject just there, because I agree with what you're saying. What you're reading is absolutely correct. But I remember the discussion being that if there is no attorney-client privilege, then there should have been records created. So we weren't questioning. Can I please finish? We weren't questioning whether the city attorney was not turning over respondent records. We were questioning whether coming from the point of view that there is no attorney-client privilege when it comes to public information requests, that there was not professional records being kept. So I think that you're doing a little bit of end around as to what the reasoning was for that particular finding on this particular case.
Understood. I appreciate that. Let's bear in mind as well that the ordinance does not require that records be created in response to a request, and we certainly can't compel any department to create records or keep them in a certain way. We can make a finding that they did or didn't and urge them, et cetera, but we're not the department head for any of these departments.
Right, but it's a little bit of a catch-22 in all due respect. Thank you. Yeah, I mean, like if you say that, well, you don't have to. I agree. Records don't have to be created, right? That no document has to be created. However, if you are the city attorney and you're giving advice to a department that to date we are determining is public information, and no record is created about that advice, then I do think it's a legitimate argument to say that you're not keeping records in a professional manner, if that is the conclusion that we're reaching. So, you can't go from... It would be too many places to hide if you say, like, well, no records need to be created, and then say, oh, but we agree that this is public information. And then when we come back and say, oh, but wait a minute, we didn't find a lack of that they didn't give information because there was no. It just, it's you can't have. It's too many loopholes in this one particular instance of the Sunshine Ordinance.
Fair point. Member Highland or Member Oka, do you have a thing? I was going to suggest that we go to public comment and then figure out what we're going to do. Oh, Member Oka, go ahead.
This whole thing is dizzying in terms of the amount of rhetoric. That's what it is. We need to do our job until the court tells us that what Mr. Clark is asking for is not public. Our job is to do what the ordinance tells us to do. Any communication regarding record requests or discussion or communication between the city attorney and a city agency regarding the Sunshine Ordinance is public. That's what we have to do. That's our job. Until the court tells us that we don't have the right to do that, that's what we should be doing. That's exactly what at the root of this whole mess. And I'm calling it a mess because I think it is.
Fair point. Why don't we go to public comment on item 3? 3 minutes.
Robert Clark. You know, I just want to say that you know, I'm just blown away by the city attorney coming in here willfully refusing to give this information, because this information was the main thing we were asking for. All the other little things that they could put in this thing that they wanted to do in the future was fine. We had no problems with it, but we specifically said from the very beginning, because as citizens, we see a law that's passed by the people and says this is public information. So we go through the system, we go through the process, we come here in front of the board, and we ask for this information. And for I don't know how long it's been, 2 years, a year, that we've been coming back and forth here arguing on this. You got a ruling against them, basically saying at the task force, let's put this new information on there. And Bill and I are arguing, yeah, the only new information we're really requesting is some kind of information on what advice was being sought by the Art Commission and what was the city attorney's response. That's the only new information we've been asking for from the very beginning. So as far as we're concerned, when the city attorney comes up here and continues to argue that they have city attorney-client on a flimsy argument that, well, this is in court and who knows, it could be turned over. So in the meantime, give us a break and don't force us to give this information. I think that's chutzpah. I think it's chutzpah for them to come in here and do that. If they're lawyers, if they want the law to change, they go to the court and get the law overruled and changed, and then they can come back in here and say, the law has been changed, we go by the new law. But until that happens, the law on the books is the Sunshine Ordinance as it is, and that section makes it absolutely clear that information should be given to the public. I am requesting that this committee, I know you didn't rule it in a violation, but he clearly came in here and is willfully refusing to give this information to this task force. He's willfully refusing to supply this information in the future, even though he hasn't won the case yet. And all I'm saying is that because he knows that's the main information we've been asking for from the very beginning, to come in here now and argue that he still has attorney-client privilege is outrageous, and I'm asking for this task force to send this back to the full task force with a recommendation of a violation for willful refusal to provide this information. That's what this whole hearing was about, for us to get this information on the books in the future.
Thank you. Thank you, and I appreciate hearing about chutzpah, one of my favorite topics.
Good afternoon, task force members. Thomas Piccarello. As I stated previously, the purpose of this committee is not to vitiate orders of determination. The purpose, hopefully, of this committee is to get the orders of determination enforced, not to have endless discussion about the merits of the case. There's already been an order of determination by the full committee. I would agree with Mr. Clark that you ought to refer this back to the full task force that comprises of 2 lawyers now and might be more legally astute on the issues of attorney-client privilege and city charter and Chapter 767. The committee of sitting right now, 4 members, you have an ideological split. So I would suggest to the chair of the full task force that she appoint another member or drop one of you. This committee, as it stands now, this is going to be dysfunctional, and you're not going to help Mr. Clark get the records that he requested 6 months ago. Thank you.
Thank you. Is there further public comment? Petrellis.
Hello, Michael Petrellis. If I understand everything here, there are records. There are written records that the city attorney has. I think open data, open government requires release of these documents. I have tried to follow Sunshine all these years, and coming to this hearing this afternoon, listening to what's being said and trying to follow it, it seems I keep coming back to the basic thing that documents do exist, but they're not being turned over. Come on, turn them over. Let's really get to the point where San Francisco government is really committed to open data. Thank you.
Thank you, Mr. Petrellis. Any further public comment? Seeing none, public comment is closed. Mr. Zittrain, again? So, in response to the comments about seeking the advice, again, looking at the first item here, if the clerks or anyone else were to request the advice sought or the advice provided on that particular item, first of all, do you believe that there are any responsive records?
I don't know. As far as whether records have been created, notes have been made by the attorney that says this is, in some cases there may be.
Okay.
It's going to depend. Yeah, it's going to depend on the method of whether it was an email conversation, a phone conversation.
Okay. If there weren't records created, then would you say that there are no responsive records, or how would you respond?
Certainly, if I knew that there had been no records created, how would I respond? I mean, in other cases, and there's nothing that's totally analogous that I've dealt with, but I think in other cases where I've gotten Sunshine requests that I'm looking at, and we basically evaluate it and we go, well, I don't think we have anything in response to this, but it doesn't really matter because even if we did, it would be protected by either its attorney-client privilege or its work product or it's something else or its privacy issues. I think we have generally handled that by advising the requester of all of that, to say we don't have any responsive records, but we want to advise you that if there were, they would likely be.
Okay,
right.
But if there weren't records, then you would start with the position that you are not required to create and you don't know, and it was 2 years ago at blah, blah, blah.
Well, and I know, and Mr. David was mentioning this, that there is a kind of a screwy dichotomy here in that the task force has the power to cite someone for the failure to keep adequate records in a businesslike manner, but not the power to actually compel the creation of a specific record, and that's kind of at odds, and that's where we're stuck in a little bit of limbo. But yes, I mean, if we don't have those, it's difficult to say, we can be compelled to create a particular type of record.
Okay, so then let's go the other way and say that there was a record. Let's say that in this hour-and-a-quarter conversation, let's say that this was likely a conversation, that Ms. Vera took notes saying, Arts Commission is asking if ba, 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 ba. My advice was da, 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 da. And there's a piece of paper that says that. If there was a request, which I think I just heard a request for that, how would you respond to that?
We are in possession of responsive records. However, those records are not subject to disclosure because of the attorney-client privilege shared between the city attorney's office and the city department.
Okay. And so you're now considering the language in the Sunshine, you're just basically disregarding the language in the Sunshine Ordinance, and this either as a result of the Grossman case or unrelated to the Grossman case, your office's position is that the provision that advice related to compliance with these laws be public is not operative. Is that what you're telling us?
I would disagree with the characterization of what is used. It may have used the word dismiss. I would, or disregard. We do not disregard the Sunshine Ordinance or that provision of it. I would agree with the characterization that we've come to the conclusion that, given the state of the law, it is not operative.
Good.
Member David?
Are we? I feel like we've been discussing this long enough. I'm ready to make a motion if that's appropriate at this time.
I think we.
Have we given?
Oh. All right. Fine. So if we're about to do that, Mr. Zittrain, did you have a concluding statement, or have you made your concluding statement?
This is my...
Wait, Mr. Zittrain, have you made your concluding statement?
I mean, I just want to, we could be here forever litigating Grossman versus city and county. Let's try and keep it to the order. Let's just try and keep it to the order of determination. That's my only concluding statement. Thank you.
Thank you. Mr. Clark?
Yes, thank you. I just want to remind you again, I have produced records here today, which I can give you copies for, that show numerous emails back and forth between the city attorney's office and the Arts Commission regarding sunshine ordinance requests all the way back to 2010. Now, I would just like the task force to be able to ask them, when did they stop the policy of sending emails, which are records, to back and forth and responding to these requests by email. And Adine Varas does most of them. I have them. They're in your files in my other case. And I don't believe that there are no records. I believe that they have email communication back and forth that they're refusing to give to me. Now, as I stated before, in several cases, the Art Commission said they refused to give me the advice that was given to them by the city attorney, claiming that was city attorney-client privilege, in spite of the fact that we all pointed out to them that the Sunshine Ordinance says that it isn't. So the Arts Commission is refusing, the city attorney is refusing, and the city attorney is saying, oh, it's okay if the client says he'll release the information. However, the city attorney has advised him not to release the information, claiming it's attorney-client privilege. I'm not caught between a rock and a hard place. I'm just squished. So you have both of them refusing to give this information, claiming it's attorney-client privilege. And as I pointed out, we were here to try and come up with some information. I agree with you. If they put on there, we're not asking them to create new records, but if they don't put in there, and there's no way for the public to find out what that information was, because they claim, we don't know, we talked over a phone, we have no answers, then they are continuing to violate this ordinance and keep records in a poor business-like manner, because the public is entitled to that information. And therefore, even though they're claiming attorney-client privilege now, they're still willfully refusing to go by your order, because they don't plan on changing their conduct in any way to provide the information to the public. So they're still continuing to keep records in an unprofessional manner, because they're not making it possible for the public to become aware of what these things are. And since these costs are borne by me and the street arts, this is our money. We're entitled to know how our money is being spent. So I ask you to send this back to the full task force, and let's discuss it there.
Thank you. Member David, do you want to make or suggest your motion?
I would like, I think this is such a key issue, and one that gets to the heart of so much of what we do, that I don't feel it's anywhere close to being resolved. And so I would like to send it back to the full task force for further discussion. And so, I'm not an attorney. This very well may fall under attorney-client privilege, but to me, the way a plain reading of the Sunshine Ordinance, this is not protected information. It's not privileged. And so a plain reading of it, right? At the end of the day, the court case might come out and Mr. Zittrain might be 100% correct, but we're not there yet. And like Member Oka said, I think we have to enforce what is in the Sunshine Ordinance until we're told otherwise. And so I would, at this point, think that this should go back to the full task force for further action.
Okay. Do we have a second?
Second.
I think we took public comment on the issue. I think we have discretion whether to take public comment on further on the motion. I guess I can be supportive of the motion. I would suggest that we make a request as part of the motion for the city attorney to consider adding that additional billing detail and to provide information back to the task force on what additional billing detail they can provide, and that might help. It certainly wouldn't make the whole thing go away, but at least it would go some
I mean, I think it's fine. I think that at the heart of this issue is not a line item on a billing statement. And I mean, I appreciate Mr. Zitron and the city attorney's willingness to try to make it clearer, but like we're kidding ourselves. We're not saying what is the heart of the heart of this issue is city attorney. What's it called? Conversations with department heads over public record requests. Is it privileged or not? And the Sunshine Ordinance says no. And we know that there's a case out there that's questioning that. But as of today, that's what it is. Anything else is, to me, really dodging the underlying question that's at hand. I'm not saying that it wouldn't do the public some good to have more information out there, but it's moving the needle tiny, and it's not getting to the heart of this particular case. And like I said, I think this case deals with so many of the issues that we deal with as a task force.
We will get to that. Would you accept adding that we request the city attorney to provide additional billing detail going forward?
In response to that, Chair Pilpel, what I heard from Mr. Zitron was that at best they'll put optional fields, and whether those fields will be filled out or not remains to be seen at the discretion of each attorney. So I really think that's just let's not even waste our time on that.
I'd like them to at least commit to that. If they're not willing to commit to that, that certainly moves me in the other direction.
I have no problem adding that to the recommendation. Moving it back to the task force.
I'll second that.
Yeah, I don't see it weakening anything. Yeah.
And I just would ask people to think about the issue. If there is written advice given, I think we have a live issue. If there's oral advice given, and I think there's a lot of oral advice given in this regard, if we can't compel and if the city attorney isn't going to memorialize that advice in writing, I'm not sure that there's a way for that advice to become public. And so, and I don't have a better solution to that, and I wish I did, but I'd like people to think about trying to solve that problem, because I think that, frankly, is very much at the heart of this.
I think it's a fair point.
However, Mr. Chair, I find it very, very unlikely that advice given to a city agency regarding the Sunshine Ordinance is going to be oral with no written record of what took place. So I don't think this actually is going to be an issue, because we're not asking the city attorney to create documents out of their oral conversation, but I think there are written records of communications between the city attorney and the Arts Commission regarding their advice to as regards the Sunshine Ordinance and what they should do. So that's the issue.
Okay. Well, maybe we don't need to add that to the motion, but maybe we will just suggest to the city attorney's office that in responding to this, if it does go back to the full task force, it would be good to explain how much of the advice given is oral advice for which there are no records, and how much of the advice includes written records, whether they're email, notes, memos to file, whatever, that could be disclosed even if you're choosing not to disclose it. So how much really is extant as a record versus not? That, and I don't know that we've gotten a good answer on that today. We've heard various things in the past. Okay, with all of that said, we have a motion. We've already taken public comment on the issue. Is there any further discussion? Do we want to take this motion without objection? there any objection? I'm not going to take public comment on the motion because we already took public comment on the issue. And the motion is to re-refer the matter back to the task force. Why don't we just restate the motion, just to be clear on it?
The motion is to refer the item to the Sunshine Ordinance Task Force with the additional recommendation to add additional detail to the billing description.
In the future, yes.
In the future.
Yeah. Okay, so, and I'm not sure that we're stating a date when this would go back to the task force. It could probably not next week. It would probably be...
It'll be at the call of the chair of the Sunshine Ordinance Task Force.
Okay, probably August.
It will be at the call of the chair.
Okay. But soon, not forever. Okay. So without objection, we'll agree to the motion?
Fine.
The motion is passed without objection. And thank you to the clerks and Mr. Zittrain. All right. So we'll hear this back at the full task force. Let's take a moment to see, is Mr. Ferrer here? Yes. Excellent. Okay. So why don't we go back to item 2? Mr. Ferrer was not here at the time, and then we'll proceed with item 4, 5, and 6. We've actually got a lot going on today.
Item number 2, file number 13082, hearing and order of the status of determination. Gonzalo Javier Ferreira against City Attorney Dennis Herrera and Deputy City Attorney Paula Jensen, City Attorney's Office, for violating Sunshine Ordinance Section 67.21D for failure to respond in a timely manner to request for determination on the status of certain records being public or not.
Okay, so let me just summarize where we are on this one. I believe that we did hear this matter once before, and this was at the full task force in March. The finding was that the city attorney failed to respond in a timely manner to a request for determination as a petition in their capacity as supervisor of records. I believe at the last hearing we asked the city attorney's office if they would develop written procedures for handling of such petitions. They have created such guidelines. They're before us in our packet. We have no specific jurisdiction over approval of these guidelines, but I think we can make some comments to the city attorney's office on them. Why don't we hear from the complainant, Mr. Ferrer, about the status of this particular item, and then we'll hear from Mr. Zittrain also about the item and the guidelines generally, have some questions and discussion. Mr. Ferrer, go ahead.
Well, thank you very much. May I please, the Commission. Basically, regarding the guidelines that the city attorney developed, they are no different from the reply I received to my complaint in the very first time. And they are not going to solve any problem. What the issue is over here, a lack of accountability, lack of ability to monitor their compliance, and lack of being able to stop these cases from repeating itself. There is nothing in the new development of these guidelines that is going to really being able to stop the repetition of cases like us. It still is totally discretionary to this city attorney to deliver a reply on time. And I just want to also bring the issue that my case was a little bit similar to the Arts Commission. I was found myself in a position where the city attorney was advising legally the department regarding the records, and at the same time, the city attorney delaying the reply. So there is a conflict. There's a clear conflict of interest over here that needs to be elucidated and needs to be clarified for everybody's sake. Those guidelines, there is nothing in these guidelines. I requested documentation that those guidelines that apparently they have developed are going to be enforced. Is some government act that will reflect that they have been adopted by the city attorney. There have not been any document reflecting the adoption of those guidelines either. So basically we have no solution. We have a violation. We have guidelines that are not going to allow, they're going to allow situations like mine to repeat themselves forever. It still is total discretion on the part of the city attorney to decide to issue an opinion whether a record is public or not. So basically, we're back to square one. The same guidelines are the ones that they actually, I insist, put in the reply to my complaint, and they didn't abide by them. So there is no controlling mechanism, there is no publicity on when the requests are made and when the city attorney replies. We only have information regarding the replies to some questions to the city attorney, supervisor of record. So basically, I'm very, very disappointed with the process and with the results. And I don't believe that the results as they are going to avoid my situation to be repeated itself. Thank you.
Thank you. We may have some questions later. Mr. Zitrin?
So casting your minds back to when this first arose, it appeared before the full task force, and I believe, then we came back here once more, and DCA Jessen was here. And, I mean, obviously the original reply in Mr. Ferrer's case took a lot longer than it should have, and as you may recall, the issue became more of a practical one very quickly, which is to say, all right, how do we stop this from happening again? And the recommendation of the task force was, well, let's at least get something down that says, all right, this is what we're going to do. We're going to focus on exactly what happened in this case and how to stop it from happening in the future. And, protocols were developed at the recommendation of EOT, and they do deal with what I do believe to be the most important part of it, which was communication. I seem to remember the communication was basically where the hang-up was when we were discussing this before the full task force. And also guidelines as to communication, as well as the issue of the complex cases that we feel might take more than 10 days to determine. So, I mean, I understand Mr. Ferrer's position as far as where this has come since the original hearing of the full task force, but these are what we've put in place specifically to prevent this kind of thing from happening again. And I'll be happy to answer any questions about them that you have. Thank you.
Some comments in a moment. Don't go too far, Mr. Zitrin. Member comments initially? So, Mr. Zitrin, like I said, don't go too far. I just had two brief comments on initially, and these are suggestions because these are your guidelines, and these are, as you indicated, internal guidelines only. There's no indication that they've been approved. There's no indication that they need any approval. They're just sort of working guidelines within the government team of how to handle the supervisor of records function. So on the first page of the guidelines, slightly below the middle, petitions to supervisor of records, scope of review. The Sunshine Ordinance requires the supervisor of records to hear. I would just suggest that you amend that to say review rather than hear.
Actually, we noticed that later on ourselves. The word hear is a little bit dicey.
Yeah. And then on page 2 generally, and sort of towards the end of page 2, I think some stronger language that, to the extent possible, requests should be responded to within the 10-day period. And in the bottom, I think then it goes into, in some cases, it may not be possible, da-da-da. In those instances, there should be a notification, da-da-da. I would suggest some additional language after that. Says, in the event that it turns out that further time is needed, that there should be, sort of continuing communication with the requester to advise them, so that, again, the general concept is 10 days where possible. Where not, you let them know, and if things continue to drag, you continue to let them know so that they know that, we're still on this. Those are just my thoughts. I think in general, this sort of, without being too specific, because literally each determination is separate and it's all kinds of fact-specific inquiry. From my perspective, these procedures do get to timely resolution and do speak to the issue of communication with the requester, which I think was the fundamental concern of the committee. So other than that, they sort of work for me. Other members? Member Oka? No? Good. Why don't we open this up to public comment, and then we'll ask for concluding remarks and decide how to proceed. Is there any public comment on this issue? Seeing none, public comment is closed. Mr. Zittrain, did you want to have a concluding statement on this? And then we'll hear from Mr. Farrar at the end.
I think that actually this case wound up being pretty well timed. Also, as eventually Ms. Jessen will be retiring, and there's going to be a changeover.
A second time.
Yeah.
Yes.
Well, we'll see.
Yeah.
So there will be, people who have not been doing this for umpty years, and they'll have good guidelines for how to deal with a situation of this type. So
Okay.
some good will come out of this.
Okay. So we've already, or I at least gave you my comments. To the extent that there are changes to the guidelines in the future, if you could let the task force or at least this committee know of that, perhaps if there are changes to the guidelines, you also want to include that in the annual report. So, the annual report is really an opportunity to both summarize the petitions and anything else related to this function. That's how I see it. So anyway, that's a suggestion. Thank you. Let's hear a concluding statement from Mr. Farrar, and then we'll decide how to deal with this.
Thank you very much. I still insist that the 10 days should be strictly understood. I don't agree with the self-regulating agenda memoranda that the city attorney have developed. There is nothing that is going to stop this from repeating itself. My concerns is that, like I find myself, is that there are going to be conflict of interest that is going to raise suspicions about the delays of certain determinations, as in my case, where the city attorney was at the same time advising the head of the department regarding the disclosure or not of the books. I have correspondence in the files to such effect, and at the same time not replying to my requirements. So that's why I'm very, very disappointed by allowing the city attorney to determine their own selves how much time they need. They never really requested in the past, and I insist, for more personnel. They never said that was a very unfair, limit. The city ordinance is strictly tells us that 10 days is the limit. I understand that there could be other situations, but 10 days is a limit. There's nothing in the new developed guidelines that is going to stop the city attorney to repeat the same issues in the future. And I'm extremely concerned because the city attorney should not be above the law. And they should be the first in compliance with the law. Had they ever saw a problem, they should have been the first requiring the city to change the chapter, to change the sanction ordinance, and they haven't done so. And still, I'm very, very troubled by this conflict of interest. On one side, the city attorney giving legal advice and rejecting to disclose documents, and on the other side, the city attorney determining what is public or not information. Thank you very much.
Thank you. It occurs to me, based on that testimony to Mr. Zittrain, again, as part of the annual report to the task force, the language that's on page 3, pulled out of the ordinance, shall prepare a tally and report of every petition. That's interesting language. I don't recall that the annual report has a chart. Perhaps if you could, going forward, include in the annual report a chart of each petition received, the date received, and the date responded, and maybe the elapsed days, so we can see how many of those responses were less than or up to 10 days and how many were more, and in particular for those that are more than 10 days, to include the intermediate correspondence with the complainant indicating that it's going to take more time, et cetera. So it's a more full report, and we can see if there was, at the end of a year, 20 petitions filed, one of which took more than 10 days because it was complicated, that would make sense. If of the 20 petitions received, 19 of them took more than 10 days, then I think we have a substantial problem and we need to deal with that in some other way. But again, I think the annual report is a good way to try to get at that. So if you can take those comments back, that would help me. Members, is there anything further we need to do on this? Are we okay with closing out this matter for the moment? Mr. Ferrer, very briefly.
Of course, I would like to see the guidelines being approved, internally approved, and also I would like to see a deadline for those comments to be incorporated to the guidelines.
Thank you.
Thank you.
So, Mr. Zittrain, if there is an approval from Mr. Delventhal or somebody else appropriate within the government team, however you want to handle that, if you do get to some internal approval for the guidelines, if you could let us know about those?
Well, I can do that now, as if there was a team working under Mr. Delventhal that developed these. I don't know if I can give you the full roster.
No.
But
Anyway, given the comments that we've made about them, if you're going to make changes to them, and if ultimately you're going to say these are, in fact, the current guidelines, not just a draft and working, okay. But if you can send us something back that says these are, in fact, are now working guidelines.
This is now the official city attorney policy or whatever.
Yeah, something like that, and perhaps provide a copy to Mr. Ferrer directly, or we can do that, but either way, I think Mr. Ferrer is interested in seeing the final adopted guidelines, and you also took the comments about the annual report and the content, so that would help.
Thank you.
Thank you. So with that understanding, members, I think we're going to close out this item.
There being no motions, this matter is concluded.
Thank you, and again, Mr. Zittrain, if there's anything further, you'll keep us posted, perhaps with a copy to Mr. Ferrer, and thank you for bringing this to us. Okay, so that's item 2. Thank you. Because we're having so much fun, let's go on to the grand jury report. Item number 4.
Number 4.
One second. Did we have copies of that item out there?
Copies are present on the tables.
Okay, great.
Item
so you've
number
got
4.
my item. Okay, go ahead.
File number 14065, Civil Grand Jury Report, Ethics in the City, Promise, Practice, or Pretense. There are handouts available on the table to the left of the room.
Okay. Give me 1 second, please. Okay, so at my request, after we discussed this item last week, seems like last week, 2 weeks ago, at the full task force, I asked that this be referred to the committees, and it was. I spent a long night, July 3rd, reading through the rest of the report several times and drafting proposed responses, which I hope people will not entirely agree with, but will take some time to look at. And those are before us. Not quite sure how we want to handle this, and I see Chair Washburn, who I very much would like to take a look at this as well. In general, as you'll read in the handout, I'm suggesting that we agree generally with the with the grand jury findings, and disagree partially with the recommendations for specific reasons. It seemed to me that most of the recommendations that the task force, in my view, should pursue seem to be appropriate for this committee, which actually works into our next item about the work plan. This actually puts a lot of work before this committee in the next several months and up to the next year. I'm certainly open to kicking some of these things to the Compliance and Amendments Committee. The full task force certainly needs to deal with this and will deal with the grand jury report again next week at the full task force. Victor, is that correct? It's on the agenda for the 22nd?
The full task force on the 22nd is scheduled to
discuss
comment
further
on the civil grand jury
Okay,
report.
and we may finalize the comments at that time or continue it depending on what happens today, tomorrow, and next week. But I just want to make clear that I did take very seriously the grand jury report, and I already summarized this. So hopefully people will get a chance to read through my memo. I'm sorry it wasn't provided earlier. We should have some discussion about it. We have members of the civil grand jury here. I'd like to hear from them and then decide how to proceed. So is there... I see Chair Washburn. Would you like to share your views?
This is, I wanted to discuss the process here.
Sure.
At the full task force meeting, we agreed that this matter would be on the agenda for EOT, for compliance and amendments, and then also for the full task force special meeting on the 22nd. And we also discussed that the matters that seemed most directly related to the work of this committee would be discussed here. Matters that were more directly related to compliance and amendments would be discussed there. But I also thought that it was, in the spirit of working together, that we offer ample opportunity for members to discuss, but importantly, members of the public to discuss the grand jury's recommendations and our response to them. So I appreciate all the work that you did, Chair Pilpel, on this. I also hope that members of this committee and compliance and amendments, members of the public, will regard your recommendations as simply your recommendations, and that we take a look at them but not have them be the basis for moving forward. And I also think that, and again, this is my opinion right now, that it seems to me that EOT should focus primarily today on recommendations regarding, or the recommendations 17A, 17B, and the two under 17, also 18. I think the two under 20, recommendations 20A and 20B are fit more neatly under the work of compliance and amendments. I'm just, that's not to cut anybody off from speaking about other things, but in the interest of giving each item a thorough hearing, that's what I would recommend. Thank you.
Great, thank you. I agree. I'm certainly not wedded to any of these. These were just my thoughts. And I'd like to hear what others think. And again, I'm terribly sorry that this wasn't before people beforehand, because I know it takes time to digest all this.
I want to, if I may, I'm sorry, I apologize. I want to thank you, Chair Pilpel, for taking the time to do that. I think that, instead of it, this is kind of a little Mickey Mousey, but I just think, just for the record, I think we should take your document, and everywhere it says task force response, I just think we should have it officially say Member Pilpel's opinion or Member Pilpel's response, so that there's no misunderstanding that this is an actual recommendation from us as a committee or the task force, so that just to reinforce what Chair Washburn said. I totally appreciate it. I think this is a great way to start a conversation. I just want to be as transparent as possible that this was, this is your opinion, and a very learned one, I'm not saying. So that's why I would...
Fair enough.
Is that...
Yeah, no problem. Do we want to hear from members of the grand jury who are here?
Sure. Yes.
Why don't we invite, I see Mr. Ravensway, Ms. Schmid, I saw Mr. Bush. Is he still? Anyway, whatever thoughts you want to share with us, either on the grand jury's process and recommendations.
Time. I want to turn it off. The light kind of goes right in the audience's eyes.
Very nice. Okay.
Do you want to discuss these findings and recommendations sort of one at a time, or are you going to take them as a group, or what?
We can take them one at a time. I didn't have any, I'm sorry, I didn't really have a plan for how to go through this.
Yeah.
Go ahead.
Because each one sort of has its own background and story.
They do.
I would think.
Feel free to go ahead. Are members comfortable?
Yes.
Go ahead.
Yeah, I think you, I mean, you state the current situation on text messages and emails pretty clearly. There is a court case that came down fairly recently, and it's kind of hard to say how it's going to shake out in the long term. At the same time, I think there's a lot of room for public discussion about how this ought to play out, and some of our recommendation is basically to have further analysis. And I think in your work plan and things like that, you're talking about further analysis. So I think you're kind of in the same space as what we're trying to recommend. We're not necessarily concerned about all emails and all text messages, but there's this in the past, there was this clear delineation between the tools you used in your public work and the tools you use privately. And I think we all recognize that, from a working standpoint, we're kind of more and more on call 24/7, and you use personal tools in a work setting and in a private setting. And to the extent that there's messages and information that's about furthering public decisions, that's really supposed to fall within the Sunshine Ordinance and also within the State Public Records Act. And you have similar kinds of analyses between the two, but they're not always going to be exactly the same. And I think people have got to kind of start thinking about what does this all mean and how does it all work in terms of generating the public records, identifying public records and generating them, in response to requests. Because what we're really aiming for in our report is to encourage transparency as much as possible. Because I think a lot of other ways of trying to control behavior don't really work too well.
So on that point, if we're just going to talk about finding and recommendation 11 for a second, what I was saying is, in general, I think we agree that just because something is by email or text message does not make it not a public record. From my perspective, it's really about the content. If it's transmitted or received by a city officer or employee and relates to public business, from my perspective, it is presumably a public record. It may have content that's not subject to disclosure, but in general terms, it is a public record and should be retained consistent with the record retention policy and schedule of that department. So
right.
if
And
that
the
means,
San Jose case is sort of saying that if it's on your private email or your private phone, we're not really going to consider that a public record.
Yeah, and I got a problem with that.
Yeah.
So I've made that an issue around here, and hopefully the task force will, go further with that. And what I was suggesting in the response to recommendation 11 is that we will consider that issue further, both in terms of policy on retention and in terms of making such a policy available and looking at department websites generally. So that was the approach that I was suggesting. Do you
But
want
it
to?
sounds like we're more in agreement than, we're not sure about this, we've got to analyze it further because we're really talking about further analysis. But
Right.
you do say you think the Sunshine Task Force ought to develop their own policy and it shouldn't just be left to the city attorney.
Should not just be left to the
Yeah.
city attorney. Correct. Right. I've said many times
And that's
before
fair
that the
enough,
city
yeah.
attorney has their good government guide, which is how they summarize their general advice about how things work in their worldview. This task force could publish its own guide to open government, reflecting our views about the world, which may or may not agree with the city attorney. And, just as we've had sort of respectful and not so respectful disagreements over time, both the city attorney and this task force have powers under the charter and under the ordinance to interpret and enforce the law. So, they may agree, they may not agree. Life is a little chaotic.
Okay.
Did you want to move on?
Well, finding 12 is really about departments not posting their sources of outside funding. We didn't quote within the finding and recommendation the precise language of the Sunshine Ordinance, but I think it's pretty clear.
It is.
And frankly, it doesn't take a lot of looking to look at the department websites. There's a lot of departments. Maybe you want to pick and choose, but you might start with planning, Parks and Rec, or Rec and Parks, some of the real obvious ones. And it's pretty clear looking at the sites that they're not in compliance. And they've got to be called to account. That's whether we as individuals should file complaints to initiate that, or whether the task force or the commission wants to do it on their own motion. That's one of the things we're going to kind of understand through this process. But beyond that, I think it's pretty straightforward.
And again, sort of in response, I was proposing to agree with the finding. I think it's true. And that in terms of the response, again, and I should have said this earlier, I felt sort of constrained because the law requires that you either agree or disagree wholly or partially, and that you respond in one of four ways and then explain. And so it's a little awkward in how some of this is worded.
Yeah.
I just felt that in terms of resources, it didn't make sense to review every departmental website immediately. That is something that I would like us to do over time, but I wanted to start by developing a model of what should be on each department's website, including the sources of outside funding. And I don't disagree that departments like Planning, Rec Park, others that have either had historic issues with Friends at the Library, for that matter, that those should be a priority in terms of this area. But I, for whatever reason, didn't feel that this was more of a priority than the other recommendations and the other work that we have to do. I agree this is an issue or a problem, but it didn't seem to me like it's a crisis that required that we stop everything and go to this immediately. And others may disagree about that.
Yeah, it seems like there's getting to be a little bit more of this, just in general, particularly with some of the tech companies starting to hand money out to city departments in a very targeted kind of way. And, as a taxpayer, I don't get to kind of put out a press release of, my money's going to fund this guy over here and things like that.
We can't apply to the Van Ravensway Foundation?
No, I just kind of write my check and send it in.
Yeah, okay. All right. Anyway, that was sort of 12.
On the calendars, I see generally you're agreeing, and then there's some further analysis. I think the one point I wanted to make in particular here on the training was that the administrative staff needs some training on the calendar keeping, because I'm not sure that the public officials necessarily pay much attention to how it's being implemented in their office.
And again, I don't disagree with that. I wanted to look at sort of training programs generally, and I think right now we only have sort of one training that's done every 2 years by the city attorney with or without the task force or this committee's input. Didn't have that input this past time. But it's just sort of an overall training on everything, which means that it touches on a lot of things briefly and not a lot of things in detail, and it's not at all tailored to the audience. And so I agree that secretaries to department heads really need specific training on what's a good calendar entry description and what isn't, and how to handle immediate disclosure requests and various other types of things that members of boards and commission secretaries don't need to worry about as much. So, it's not just one size fits all, it's what makes sense to that audience. So that's what I was suggesting in the proposed response.
And then with respect to our recommendation that Ethics Commission staff collect the official calendars and post them online, your thought is to basically call on department heads to start posting stuff online.
Yeah. I think to the extent that department heads or their staff are required to maintain calendar entries, it's their responsibility. I don't want to shift work to this task force or to the Ethics Commission. I think that the departments, and these are, in many cases, departments with a lot of staff, a lot of resources. If they've got an immediate secretary that's maintaining the calendar, how hard is it to put it online? I don't know what, and I apologize that I didn't look at the mayor's office to see if they're still listing their calendars. I believe Mayor Newsom actually or his staff, had their calendar items up 3 days after and maintained that. And I think that sort of worked, notwithstanding anything else that happened. But anyway,
Sure.
I think that this is, if we're going to make this a meaningful requirement, it doesn't seem to me like it's an unreasonable read to ask departments to post this. That seems to me that it's a departmental function. I don't suggest moving it elsewhere.
Yeah, we've been learning lately it's, the process of getting things posted is a little more complicated than we thought.
But again, that's something that the departments should work through.
Yeah.
Somehow they manage to get agendas and minutes and notices of things that matter to them up. How about the things that matter to the public or the public has mandated be up? Mm-hmm. It's a concept, yeah.
We're going to take public comment.
We're going to get to public comment.
Yeah.
I saw a hand over there.
Yeah. But I do just sort of maybe have a question for your own staff about how your agenda gets posted. Do you post it yourself directly?
I personally post my agendas online.
Okay.
So
But I do know a lot of departments do need to send it out to IT, and there is a delay when they do that.
It depends on the content management system and who's trained to do what, and passwords
Yeah.
and structures. Yeah.
Interesting.
We don't have to get into HTML and PDFs and whatever, all that today.
Yeah.
But another time. All right.
But it works well for you. Yeah, it's good.
Anyway, that's where I think we were on the 17 department.
Okay.
On 18, we weren't asked to respond to that finding or recommendation. I just thought that was pretty important, and I thought, what the heck, why don't we chime in on that and agree and recommend that the board implement it? It seems like a fairly easy no-brainer to me, but maybe that's just me.
And, finding 20, I think really will be taken up tomorrow in some detail. So I find the background that you put down here very interesting, and a lot of this is new to me. So
And
thank you.
that was the one that I felt was much less about this committee and much more about compliance and the full task force. And so, again, this was just a first cut, and, I'll leave that to compliance and the full task force. These are just my views, and I'm open to how we deal with it.
One point we were trying to get at with all this is, leaving aside the question of a backlog and things like that, you guys have some really long meetings. And people just arguing over cases, and having an independent hearing officer could offload a lot of that time and energy of so many people sitting around just listening to something, because there's broader policy issues that the task force can be looking at, and that's sort of what we're driving at there. It wasn't a concern of, oh, you've got a lot of backlog and it's got to be worked off somehow. It's more like, geez, you're meeting for 4, 5, 6 hours at a time, and a lot of it's really about these cases.
So I'm kind of, I wish our city attorney was here, because the question I would have is that if we go with that recommendation, which sounds wonderful, does that comply with the Sunshine Ordinance?
Well,
That's
a good question.
Yeah, can a hearing officer, do what you're asking?
And if that's a problem, that should be part of the response, I would think.
And that, in fact, was why I suggested that I think, Member Highland, Chair Washburn, that we've started to talk about different ways to handle things. Maybe we do some things that I think we're going to be examining this issue shortly, or we're already into it, that what we're doing now isn't really working in a lot of ways. How can we do it? Or it's working in some ways, but it's not that efficient. How can we do it better? How can we do it differently? And I think we're going to explore some of those ways.
Yeah.
I wasn't suggesting any particular outcome other than let's look at what we're doing, which I think is what we're doing now. Remember?
And Mr. Chairman, with all due respect to the backlog, the backlog was created because the task force was not able to meet for about 6 months.
Oh, yeah.
Because the board of supervisors did not appoint someone with a disability to the task force. So rather than be in non-compliance, the task force chose not to meet. So we're trying to deal with the backlog, and I don't know how we're going to end up resolving that, but we have quite a backlog, and the public has let us know that we should take care of it.
To be fair, though, I think the backlog is not just because of it. It's because of that in part. But we also, at this point, I think, are getting more complaints a month than we're disposing of. So that's a problem. And yes, the manner in which we get complaints, in some cases, complaints are complete and ready to go and pretty obvious. And in other cases, they're not, and they require a lot of effort at meetings. So there's a lot to how we process complaints, and that too needs to get explored. So again, we're not going to resolve that today, but that was just my thinking that it really is a broader discussion. But these are all, I want to emphasize, these are all really good issues, and although it appears that I'm not suggesting complete agreement with the grand jury on everything, these are absolutely issues that are before us, and there are a variety of ways to deal with them. And so I very much appreciate that, and I hope that at least the three of you and others will continue to engage with us. This is helpful. I don't think you have any axe to grind on the outcome of complaints or a process other than that people have good process and that we reason through the issues before us, which is, I think, a good approach. Member Highland.
I had a question through the chair for Mr. Ravensway, and touching on what Member David said about, can we have an independent hearing officer given the charter that we operate under? I'm curious about that concept. Is that something that you've seen in action elsewhere? How would it work? How would that officer be selected, voted in? If you can just give us some examples so that if we do go down this road, give us a picture of what it might look like.
Or do you want Chairperson Schmidt to talk about that? Excuse me.
She's smiling.
She can. I will say I had some very brief discussions with the city attorney about this, not in sort of our fact-finding, but we were advised that there is sort of a group within the city and that some of the departments use hearing officers, and that, from making a recommendation standpoint, this was sort of an adequate starting place. But I think, we have to hear more from the city attorney about how to approach it. The state has, as I understand it, more of an office of independent hearing officer that you can actually contract with.
The Office of Administrative Hearings.
Yeah. Actually. And they would send people in. I think the city may contract with individuals. I'm not sure how they do it. It's one of these things that, you can't kind of say, oh, this is the way it's got to be. It's got to be something that the Sunshine Task Force is interested in, the Ethics Commission is interested in, and then, you kind of work out a framework so that you end up with a hearing record that sort of meets the purposes of both bodies if need be.
And are these officers, are they trained in the law? Are they basically arbitrators? That's what it's sounding like to me.
They would be trained in the law, yes. It would. I don't know that you'd call it necessarily an arbitrator. They're really tasked. I think Elena can speak to it more in the public utilities arena, but they're really tasked with putting together a hearing record that's complete. And if issues of law need to be briefed, they're briefed and decided, or a proposed decision is put on the table. And then the commission or the task force would render a final decision based on the record that's handed to them. Well, you'd have a pretty complete file at that point.
Mm-hmm. So it sounds to me, one of the things that's jumping up to me is a question of budget. We're already meeting with the clerk this week about whether we can reenact some of our standing or once standing committees. So again, this, if the city deems it a good, practice, and if they can budget 1 or 2 hearing officers to us, that might be interesting to have them in those initial.
Yeah, we are kind of dodging the budget issue here.
Yeah.
Okay. I think, to be fair on a couple of points, the rent board has hearing officers. They're the largest group of hearing officers or administrative law judges, whatever you want to call it, in the city, because they get a regular caseload of complaints about landlords doing the whatever. And I don't know how much discretion the hearing officer has to make a final order, or if that goes to the rent board, or if there's an appeal process. I don't know enough about that. There are other city officers and department heads and various folks that hear other types of matters, labor standards enforcement, contract disputes, whatnot. So this whole area of hearing officers can get complicated, and it does get expensive. I think one of the things that we need to think about, as you properly indicate, do we want to have more committee meetings? Do we want to have more public hearings? Do we want to spend $1 gazillion and hire an army of hearing officers to hear? How much of a bureaucracy do we want to create to deal with sunshine? I think my view is we should have enough bureaucracy to make it work, but not too much that you sort of suggest that everyone should be filing complaints every second of the day, which I don't think makes sense personally. So there's a lot to balance here. I heard a suggestion we should take public comment. Did you want to present any further from, I see Mr. Bush joining us. And if Ms. Schmid wants to present as well, and then we'll open it up to public comment. Welcome, Larry.
Hi, I'm Larry Bush. I'm a member of the grand jury that worked on this. I'd just like to point out a few things that I believe would be easy for this committee to immediately recommend. One is that a letter can go to every city agency explaining what is in the current law on calendar requirements so that they are aware of it. There is nothing now in the training for the Sunshine Ordinance Task Force that even mentions the calendar. It's not in the city attorney's guide. It's not in the online training that all people say that they've taken. And there's nothing that's come from this task force that explains what are the requirements in a calendar, including who you meet with and what the topic is, whether it's in the office or not. So that seems like a pretty easy thing to do. The second thing is the issue of outside contributions to city departments is a very timely one, and I think that postponing that for a study that takes 6 months or a year does not serve the public well. We have just seen Google give $6.8 million to MTA. There's nothing on the MTA site that says we just got $6.8 million, what it's for, who gave it, and why. And that's only one example. You can go through the behested payments, and you can see city officials who have asked various corporations to make contributions for parks or other programs. It's all there. You could have a starting point of just alerting that those things need to be listed by calling Recreation and Parks, for example, or MTA, and saying, Where can we find this on your webpage? Oh, we can't. When are you going to put it up, and where is it going to be? These are steps that do not require months of study. These are steps that would serve the public now. In general, some of the statements that the calendar requirements can't be implemented because they're not reasonable. I think it's unreasonable to expect citizens to look through every city department to look at the calendars. They should be in a central place, because otherwise, how do you know what's really going on? If you are working on land use policies, you want to know who someone's met with in the mayor's office, in planning, at DBI, at the Board of Permit Appeals, or with members of the Board of Supervisors. You don't want to have to go through every city agency and begin trying to track things down. The point of the sunshine is to make information readily accessible to the public. By spinning it out to 50-some city agencies, you're doing exactly what the conservative Republicans hope will happen with every kind of labor law. Send it down to the states and not have any federal laws, because they know they can do better at state levels than they can with the others. And you're going to find many city departments will come up with excuses about why something can't be done, or else they would have been doing it all along.
Okay, so, Mr. Rick, may I ask you, I want a clarifying question, if that's okay.
Sure.
So I'm curious, so you're recommending one centralized calendar. I just want to be clear, like that's, so like it would be like the city's calendar and every department head's calendar would be on that one centralized.
Right, a central database, just like we have a central database for everybody's Form 700s.
So okay, so you're saying, okay, that's helpful. So what you're saying is that a web page that would have the link to everybody's calendar.
That's right.
Okay, very good. Thank you. That's helpful for me. Thank you.
In general, I think that
And then Member Oka had a follow-up.
With that in mind, Mr. Bush, I would think that locating such a document or such website within the public library might start in the right direction in terms of a place where a member of the public could go to find within the government documents section what's going on with city government.
I think that's a useful alternative of moving forward. One of the things that we've seen is that while City Hall has adopted a posture of making information available, it has not fallen through with it. So, for example, in 2012, Mayor Lee issued an order that he was going to have quarterly reports on every city commission and the attendance for all commissioners. That stopped after 4 quarters. There has been nothing updated since that time. So nothing in 2013, nothing so far in 2014.
Really?
I think it would be just as well for the task force to remind the mayor of the commitment that was made to provide that information to the public. So there's a lot that you can do that's already supposed to be in place, and you just need to kickstart it a little bit. Make sure that the tires are all inflated. Thank you.
Thank you.
1 second, I'm just looking up, as you requested, the mayor appointments. Was Ms. Schmidt going to talk to us for a moment? Welcome.
Thank you, Elena Schmidt. I won't make any comments. I think that Rob and Larry have covered everything. I'll just make a comment on the last thing that Larry Bush just said, which was about the attendance. That was in the final report that we came out with, which is a report on the commissions.
Oh, I haven't seen that one yet.
Yeah, and that, and we talked about attendance in that one. So that's where that piece of information came from.
One moment. Yes, why don't we take public comment while I'm looking? Thank you. Is there any public comment on the item?
Point of question before you start the time, please. I have a question. What are you taking public comment on right now?
On the civil grand jury recommendations and the task force responses.
And you're, okay. Okay,
either something that's here or something on your mind. Go ahead.
It's all related. Okay, regarding the part about, my name is Michael Petrellis, by the way, for the record, about whistleblowers. This, to me, applies to members of the public, too, not just people who work for the city who want to blow the whistle. I blew the whistle on a nonprofit, filed a complaint with the city attorney about this nonprofit, and started public law, etc. And now, if I want to do follow-up, the city attorney says, we can't comment. We can't tell you what is going on. This hinders people from coming forward and blowing the whistle because we don't know what happens to the complaints when we blow the whistle. Regarding the ethics site, it is very difficult to find how to just search for donors. I believe it takes at least 7 steps to get to the search engine for donors to see who's donating. Regarding recommendation 17A to post calendars on the ethics website, I, at this point, would like to recommend that the departments, which all have public information officers, that they say on their sites, our calendars are available at the Ethics Commission website, and they link to it. In terms of helping ethics develop the software to post all of those records, well, there's this thing called big tech. Let's call upon them for help. I believe the mayor has an office of technology. Those folks should be called upon to make it as easy as possible for each department head to get all of the calendars for the top people in the departments, not just the heads. But their top deputies to also post their calendars. And then you go to the ethics department and you see for the health department, the AIDS office, the environmental department, all of those top people, their calendars are also posted at ethics. The Board of Soups in December, I surveyed them. They all gave me their calendars for that month. I asked them all to post them on their websites. They have 3 paid staffers. None of them have posted their calendars on their own websites. Very disappointing. Finally, this grand jury report talks about transparency and doesn't talk about putting the Sunshine Task Force on television. I believe it is long overdue for this task force to be on Channel 26. Thank you.
Thank you. Is there a further public comment? Mr. Piccarello?
Thank you. I want to concur with previous comments by Chair Washburn and Member David regarding this document. This is your recommendations and your recommendations only. So I would suggest that any motion to concur with this document not be passed. Secondly, let me say, I think that what the grand jury, the grand jury is suggesting regarding a hearing officer is that they have no confidence in this task force clearing up the backload of complaints. And I would have to agree with them. You can talk from now until the end of the year about how you're going to deal with the backlog of cases, but you're not going to deal with the backlog of cases. So I suggest that you strongly entertain the motion or the idea or thought of an independent hearing officer to deal with the complaints that are pending. Because with the backlog of cases, you are really sending the message to city departments and city agencies that they really don't have to comply with the Sunshine Ordinance. Thank you.
Thank you. Is there any further public comment? Seeing none, public comment is closed. So a couple of points. As to Mr. Bush's comments about the calendar requirement and the source of outside funding, I've rethought that a little bit. I don't have new language, but I will take it on to draft a letter to bring before this committee next month to send to department heads, reminding them of the calendar requirement, offering some thoughts on that, and reminding them of the source of outside funding requirement and asking them to post that, reminding them of the requirement to post that on their website. I agree in thinking about it further that we can do that and then come back to whether or not they've complied, and if so, how. But we could certainly draft that letter, and so I will take that on. As to the rest of the report and recommendations, what I would suggest, if we can, is to merely refer these proposed responses to the Compliance Committee for further discussion tomorrow and to the full task force without recommendation. So they're just simply before the groups for discussion, and we will discuss further tomorrow and next week. That's my thought. Does that work?
Yeah.
Members? And again, if people have other ways to cut this, I was just trying to do some work here, which, whatever. It's up to the full body to make decisions.
It states clearly these are your thoughts, so
yes.
I have no problem with this.
Fair enough.
I'm wondering if we can incorporate some of the discussion we've had today into these answers and present that for the full task force, just so we capture this information, this back and forth.
I will try to do that in a next version, but at least for tomorrow, why don't we take this to compliance and see what they think? And then I'll try to do some more work after tomorrow and before next Tuesday's full task force meeting.
Yeah, in particular, like Mr. Bush's 4 recommendations, I made notes of those, but I think that's...
And feel free to add your as well. Member Oka.
Yes, while I'm thinking about it, and while we're on the topic of this huge document, one of the things that I've been asking city agencies to do for I don't know how long is to make documents readable by Adobe Acrobat or any reader program that's out there, because scanned documents are not readable by most programs that read. And I'm a very auditory person. I rely on the reader to read the document to me. And until we can get, we're in an age of things should be available to be readable to everybody, blind, deaf, everybody. Mr. Young, is there a readable copy of the Sunshine Ordinance, Section 67, in the city library someplace? Or am I going to have to read through the whole document without help of my reader?
Well, Member Oka, I believe the ordinance itself is online as an HTML document.
Well,
I don't know if it's available as a searchable PDF. If you're looking for that, we can certainly make that happen. In general,
I have not. I've searched. I have not found it yet. That's why I'm asking: is there such a document that exists?
I'm not aware of that type of document. I'm just not tech savvy enough to know what that would be.
I'm sure that we can find out.
Well, so to Member Oka, I do have on the list, we're going to talk about this in a second, reviewing our documentation on our website and also looking at other departments and what information should be on their website and how that should be presented. We talked months ago about searchable PDFs being the appropriate standard, not scanned documents, not anything else.
Well, to be sure, I have made this request publicly through the Mayor's Office on Disability, and I have yet to get a resolution to the problem.
Okay, why don't we hold that for further discussion under item 5 with other member initiatives? As to the grand jury report itself, and I did just take a quick look, you had a short report on commission websites and city websites that just came out. I wasn't aware of that report. I will look at that if that's appropriate. It didn't look like there's any required response from the task force, but it certainly, I think, dovetails with our work to look at departmental websites. So we may bring that before the committee next month for further discussion. It seemed like it was, it's short, but it may be germane to what we're doing. So on the grand jury report and recommendations, can we take a motion to just transmit these proposed responses without recommendation, again, to compliance and to the full task force? Do we need a motion for that, or does that work? Member Oka, do you want to make that?
I'm okay with it.
And seconded by?
I'll second.
Member David.
Is there
Just
any
getting this
objection
down.
to this motion to refer the recommendations to the Compliance and Amendments Committee and the Sunshine Ordinance Task Force?
Without recommendation.
Without recommendations. I see no objection.
Okay.
Okay, without objection, that'll be passed.
Okay.
And that'll be discussed further again tomorrow, right here in this room at compliance, and next week back here at the full task force. Okay?
And I do want to also note that the chair has stated that he will, reading my own notes. Draft a notice to, my apologies, I believe it's concerning notifying departments.
I'm doing three things. I'm going to try to revise the grand jury recommendations based on the discussion we just had and whatever happens tomorrow. I'm going to draft a letter to departments or department heads about the calendar requirement and the source of outside funding. We will discuss that again next month. We're not sending the letter until it's been reviewed here. And we will possibly discuss the other grand jury report about commission websites. So those are the three notes that I had as takeaways. Okay? Does that work for everybody? Okay. And thank you again to the grand jury people. Really, really, thank you. Okay, are we done with item 4?
Yes.
Okay. Why don't we hear item 5?
Item number 5, Education, Outreach, and Training Committee, Member Initiatives and Work Plans. There is one handout.
Okay. And thank you again, grand jury people. Stay if you'd like to, or not if you don't, and feel free to come back tomorrow and next week. Okay, so you have a handout. What I attempted to do here, which I try to do periodically, is suggest that there's actually a plan here. I don't know if there's a secret plan to end the war, but this is the not-so-secret plan of what I had in mind. The first group of items was what we were trying to do today, and then sort of each section was sort of a month at a time. So I was suggesting next month we would revisit the Board of Supervisors Budget and Finance Committee, City Planning, Public Records, the calendar requirement, and all of this, and start to get into past committee minutes, and then in September, et cetera, et cetera. This is certainly flexible and subject to change. I'm happy to hear if people think I got this wrong, or if there are new initiatives that members want to take on, or things that people want to take the lead on besides me, because I feel like I'm doing a lot of the prep work here, but I guess that's what happens when you're the chair. And then just finally...
Chair Washburn, can you wait just 2 minutes, please? I'm sorry. Wait, I just wanted you to hear one thing.
Okay. All right, so why don't I shut up for a second and hear what others have to say. Member David.
Yeah, so the only thing I want to say is once again, I totally appreciate Member Pilpel and his diligence on putting together this work plan. I think it's great. But I want to come back to, I think that as a task force, our number one priority should be to try to work down the backlogs of cases. And I believe that I sent an email to Victor asking him to forward it to Member Washburn with a recommendation that we consider as a task force actually not doing subcommittee meetings for 3 or 4 months so that we could do 3 full task force meetings a month, which seeing six cases at each task force meeting, which would get us through 18 cases a month. And then theoretically, within 4 to 5 months, we would actually be kind of caught up on that. Now, that might then put additional burden on our subcommittees down, but that seems like if we're going to be here 3 days a month for a regular task force meeting, a special meeting, and a subcommittee meeting, that it seems like that the subcommittee meeting is the one area that we maybe could put aside and make that an additional special full task force meeting and literally get through 18 cases a month that way. So that was one of the something that I was hoping that we could discuss.
Right. Yeah, I think that's an interesting idea and one that we should seriously consider. I also, I guess Victor mentioned earlier, it was Member Highland mentioned that we'll be meeting on Wednesday with the clerk of the board regarding reconvening our other standing committees, namely rules and the complaint committee. The complaint committee, we were looking at that as a way to help bring new cases to mature them so that when we get them at the full task force, they're ready to hear, determine jurisdiction. But that's kind of possibly a long range plan. But right now, I haven't heard from all the members about what committees they want to serve on. So this is, right now, the committee structure is kind of in flux. That's one issue. And then getting resources for all of our standing committees. We have 4 of them in the bylaws. It's a matter of actually time for Mr. Young to staff. So we have to be really creative, and those are kind of the things that are up in the air that we're going to be just making some determinations about in the next couple of days. But I do agree we've got to get the backlog taken care of. It's hard to have the energy and the time to do the other things we need to do to move forward. So your idea is an interesting one, but like I said, I haven't heard from all the members about what committees they want to be on, and so haven't determined that structure.
Right, but just to be clear, right, like my recommendation is that we basically, put aside the subcommittees for a couple of, 3 or 4 or 5 months so that we have 3 full task force meetings a month and our goal would be to get through 18 cases, like 6 cases per task force meeting, 18 cases a month. We theoretically have a 50 case backlog. So as new cases come on, I would see that if we kind of had that type of structure, a way to get through everything in 4 to 5 months.
Right.
I just want to be clear that I was saying.
The only thing is there's some things that compliance here is, for example, that we wouldn't want to put off for 6 months. Every time we issue an order of determination where there has to be some enforcement or some follow-up. So we'll work it out. But I think it's you're thinking boldly, which is what we need right now.
I think this is exactly the conversation we need to have at the full task force next week. So I'm hoping that you'll have an item to talk about how to deal with the backlog
absolutely.
and this question of committee structure and resources.
But I just wanted to let you all know where we are and what we're looking at, all the range of things we're looking at.
And I'm also not suggesting that there's any right or wrong answer. I think continuing to do things the way we have been isn't working so well. So doing different things is good, and I think we all need to be creative about how to do that.
Absolutely.
And through the chair to the chair, I was dying to say that. One of the things.
Thank you, Mr. Vice Chair. No, go ahead.
And from Member David, one of the things we were thinking of is along the same lines of what you're thinking of is actually hearing cases in the subcommittees, as far as determining jurisdiction, as far as maybe even mediating at that level and staving off. Another thing we're thinking
recommending a solution.
Recommending a solution. And I think another, and again, we'll discuss this all in full meeting, is looking at Victor's, our clerk's role. He's really the first line of defense, if you like, or the first line of, I'll call him the ambassador to people filing complaints. But maybe having some more help at that level, where he would maybe we'll forward it to. Well, would you like to talk to PILPEL members, David, on this committee, and see if they can work out a mediation for you, and that way they get what they want, they get the satisfaction they're looking for, the documents they need from the city department, because we're engaging them at that level, and it doesn't need to go to the full meeting. So.
For some, not necessarily for all.
For some.
Right.
It's just a choice. It's an extra choice to give the members of the public, and some will take it, some won't. But at least it's, again, not only are we breaking down the backlog, but we're also trying to streamline what comes to us in full meetings. This is going to be a great discussion, I think, on the 22nd.
I do agree with that point in that I do get responses from departments, but in terms of review by the task force, there really is no mechanism for that, to see if there is anything else the task force would require based on the response from task force and from the department based on the complaint.
Again, I think this is the beginning of the discussion we need to have next week, and I hope we have a good discussion. And, again, there's the only wrong answer, I think, is to just keep doing what we're doing, because we need to do it differently. So back to the work plan generally, I was just assuming that until we change what we're doing, that we're going to continue to at least have a committee meeting once a month, and that we would generally have this work to go through. Did you have anything else?
No, thank you.
Thank you, Chair Washburn. See you tomorrow. Talk to you later. Okay. So, yeah. They didn't need you on a soccer team, but never mind. All right. So again, until and unless we change what we're doing, I thought that we did have some workload to deal with here, and some of these were follow-up items. Some of these were things that came out of the grand jury recommendations, and things that we've said we want to do and that we do want to do. So I was just intending to proceed with this until things change. Member Oka's suggestion about what's on websites and what is kind of the standard for how documents go out. I think that's kind of buried here in reviewing agency, board, commission, and department websites and developing model for content. So I was intending to address that there.
Is this basically our backlog? Is that what this is?
Yeah.
Okay.
At least at the committee level. Well, it's not so backlog. I mean, this is also affirmative, proactive things that we want to do. So if there's anything that I missed here that anybody wants, if there's anything that you want to attach yourself to as being the lead on, feel free, let me know. And this is flexible, so as things come up like today, this will get modified. This is like a work in progress. But I did want us to at least see it, either adopt it if we want to, or I don't know that there's a need to, but at least know that there is sort of a plan here. It may not always appear obvious, but I do try to plan a little. So. Okay, why don't we, unless there's further discussion, open this up to public comment. I see a strong hand and an outstretched arm, and let's hear from Mr. Petrellis.
You may call it Petrellis comment, if you will. So, regarding the length of meetings and reducing the backlog, I'd like to point out that one thing I've noticed, it certainly happened here today, is that you guys don't keep track of the time. You say approximately 20 minutes for item number 2 with William Clark. That went on, I believe, about 50 minutes. I'd like to suggest that just like there is a time limit for the public comment, there should be a recommended time limit for task force members to make comments. So we're soon going to have a full task force of 11 members, and if all 11 want to speak without limit, the meetings are going to get even longer. Please, when you're saying approximately 20 minutes, someone on the task force say, hey, we're going quite over that approximation. Regarding nonprofits, on David's recommendations here, Chapter 12L. Yeah, I'd really like for you to look at that after my recent complaint involving the Charlotte Schultz Committee, San Francisco Host Committee, and on further down, review public library government information. There's this problem where the nonprofits are required to hold 2 public meetings and send on paper the times and dates of their meetings to the library on paper. There is nothing on the web about where and when those meetings are. So you either have to go down to the library or call them up, as I do frequently. We need to get that addressed in terms of that information is at the library but not online.
Which is why you're going to come back to that meeting and talk about that. So when we get the library folks here, we'll talk about whether or not they can scan those things in and put it online.
And I get an extra 10 seconds since you ate up my 10 seconds. Finally, what's not here, and I'd like to have this addressed, is I recently did a dance online with the City Attorney's Office regarding the custodian of records, Matt Dorsey. He was out of the office for a good number of weeks. There's no policy at the City Attorney's Office in terms of how to access Matt Dorsey's records. I was questioning, well, God forbid if he's passed away, how do you gain access to his public records? Or if he's stuck at JFK in a snowstorm, how do you comply with sunshine within the required time? And they said, and I can share the emails with you, we do not have a policy about someone in the office having access to all of the records for the public information officers at the City Attorney's Office. I'd like for you to consider in the future, because you have plenty on your plate, that each department is able to access records if the custodian passes away or is stuck in a snowstorm back east. Thank you.
Or is otherwise unavailable. All right. Comment noted. We will consider that. Mr. Piccarello.
Thank you. I'm most interested in a couple of these suggestions. Number one is Chafee versus the Board of Supervisors Budget and Finance. As you know, there was an order of determination, and it's still in this committee from last year. So this year, the supervisors did the same thing regarding public comment, which forced me to file a willful violation by the Budget and Finance Committee individually, not as a committee, individually. So the other item is 12L. It's a very important issue. Nonprofits in the city do at least $600–700 million of city funds a year, and there's really no transparency, accountability, or sunshine regarding nonprofits in the city. So I invite you all to look at 12L and see that there's really no stick to have nonprofits comply even with their own 12L. And finally, I like the suggestion by Member Highland regarding putting some of these complaints into some of your committees and not having the matters be heard by 10 or 11 members. You really take too long in adjudicating each individual case, so you'll never get caught up. So the suggestion of having some of these matters, perhaps maybe by agreement by both the complainant and the respondent, be heard by 4 or 5 members, that would help. One more thing. It's absurd for you to rely on the city attorney when he is a respondent. All right, so when the city attorney is a respondent for not providing you records or not allowing open meetings, you need to get somebody else to give you legal advice. obviously the city attorney has a conflict of interest when he is a respondent. So it's absurd to rely on a deputy city attorney when the city attorney's office is a respondent. Thank you.
Thank you. Any further public comment? Seeing none, public comment is closed. On the work plan, I'm not sure if we need a motion. Do people want to not do anything? Okay, so we will just see it, accept it for what it is, take no specific action, and just be aware that there's a work plan moving forward. Fair enough? No action taken.
There's no action taken on item number 5. Item number 6, public comment. Members of the public may address the Education, Outreach, and Training Committee on matters that are within the committee's jurisdiction, but not on today's agenda.
Hello, Michael Petrellis. Hello, Michael Petrellis again. Television. I really would like to see the monthly meetings televised on Channel 26, made available at ssgov.tv as video on demand. I think that Sunshine requires sunshine on television and on streaming. Earlier this year, Barbara Garcia across the street, head of Department of Public Health, just made it happen after a few years of a number of health advocates demanding that those meetings be aired on TV. There are now cameras in their third floor auditorium. Those meetings started airing in March. It's really terrific. I understand that this Sunshine Ordinance Task Force does not have the huge budget that Barbara Garcia has. That said, I think, though, that there should be a resolution to come from this committee as part of education and outreach to the folks who cannot come here on Mondays or come to any of the meetings, that you have to do education and outreach through streaming and Channel 26. I think a resolution saying we endorse doing this, we would like the Board of Soups to consider an allocation to have these meetings, just the monthly meetings there, to understand not the subcommittee things, that you guys need to look at this. Everyone I've talked to doesn't see a problem with the meetings, why they shouldn't be broadcast, okay? And lastly, I think, again, if the money can't be found, why not call on big tech? Ask them to find the volunteers, get a camera to sit here, a camera person, and stream it. It is really, really important to bring sunshine to sunshine. Thank you.
Thank you. Further public comment? Mr. Piccarello?
I would agree with that. The best way to have sunshine in the city is to televise these proceedings. It would be a great deterrent to a lot of city departments and city agencies to have to come in front in Channel 26 and give their positions as to why they're not allowing public records or allowing open meetings. So I think that would be probably the best way to have sunshine and compliance there too, is televise the proceedings. So you need to take that extra step and push televised proceedings for your proceedings. Secondly, let me say that I think this committee needs one of the lawyers on the full task force here. You don't have the advantage of having the deputy city attorney at least, so you're at a disadvantage, particularly when the city attorney is giving you a legal argument. So I would encourage you to ask through the chair to have one of the attorney members sit on this committee. And as I stated previously, four on this committee is not good. you should have 3 or 5. So you have one of the attorney members sit, perfect, 5. Yeah. Thank you.
Thank you. And just on that last point, we do now have 2 attorneys and 2 journalists on the full task force, so I'm hoping that we get one of each of those on this committee. And although it's
we're already talking about it.
yeah, and it may be a tough trade, but we might have to trade Member Oka. I'm not sure that Member Oka is worth the same as an attorney and a journalist. I think it's not a fair trade for us, but we'll see what we have to do.
And actually, on that point, I like the idea of having a non-city attorney advise when the city attorney is a respondent. I think one of our attorney members can do that for us. Makes sense to me.
We're thinking about that. I mean, certainly the Deputy City Attorney Cola is, walled off from the rest of the office on advising on those matters, but there may be further things that we can do on that. So we'll continue to ponder that.
In my view, it is clearly a conflict of interest when the city attorney is a respondent to have a member of his staff advise.
Understood. Okay. Anything further on item 6? Seeing none. Item 7.
Item number 7, announcements, comments, questions, and future agenda items.
I have none. Any members? Anything? I think we did enough. Is there any public comment? Seeing none.
Move to adjourn.
Is there any further business before
There's
the body?
no other items on the agenda.
And we are adjourned at 5:35. Thank you all very much. Our next regular meeting is Monday, August 11th, 3 o'clock right here. Thanks.